We will look at what parties do in the aftermath of an award or a judgment given by an international court or tribunal. Now, we know that when the international courts and tribunals give well-reasoned judgments, detailed awards, we hear it, we jubilate if we won, not happy if we did not, if the state that didn't win is not happy, the state that won is happy. But then after that, we don't hear too much award from it. What is involved when states have to comply with these judgments or awards regarding their maritime boundary delimitation disputes? What are their concerns and what can they do if they do not agree with the judgment or the award? That's what we're going to talk about this afternoon. Now, the implementation process depends on the type of judgment or award. And that in turn also depends on the scope of the consent that the parties give to the adjudicating body. Now, the adjudicating bodies can be either the ICJ, that's the International Court of Justice, it can be the International Tribunal of the Law of the Sea, or it can be an Annex 7 tribunal or a special chamber of ICLOS, as we had in the Ghana Côte d'Ivoire case. The constitutive instruments of that tribunal, as well as its procedural rules, spell out what circumstances and how the states can invoke the court or tribunals, jurisdiction or after the award or judgment has been rendered. Now let's look at a few examples of what I've just said. In the Ghana Côte d'Ivoire case, for instance, you look at what the parties agreed to give to the tribunal and what the tribunal did for us. We asked for the establishment of a single maritime boundary between Ghana and Côte d'Ivoire in the Atlantic Ocean, limiting the territorial sea, the exclusive economic zone, and the continental shelf. And we included the continental shelf beyond 200 nautical miles. Why would we even do that? Because we knew that we had gone before the UN Commission on the limits of the continental shelf. We had made a submission to an extended shelf, and we had got it.
So came for this high-level conference and all the other organizers from the University of Ghana. It's really a pleasure. On the other hand, so I'll try to tell the lessons I learned from those cases without actually mentioning the names of the states and of the cases, because as a lawyer we still have a duty of restraint. So it will be a challenge, but I hope I'm gonna make it. Let's try to share the presentation. And actually, what my presentation is. The one who seizes the court, the state who seizes the court, because the application sets out the fundamentals of a case, and it may define the scope of the proceedings, and from this point of view, it is an important advantage, but this is not an advantage which cannot be overcome by the defendant states. Memorial and counter-memorial, well, you just present the case. However, it's very important to decide from the very beginning what are the claims, because any change, any renunciation to a claim during the written pleadings will be perceived as a step back. And it may raise some interrogations on the part of the judges. Why such a step back? Why didn't you believe your case, and so on? So when we are approaching the written pleadings, a lot of time is devoted to the formulation, to the drafting of the submissions, of the final conclusions. because this is where really we formulate the claims, and this is the element of expectation that we will make public in the end when the case goes to hearings. And there is the question of will there be a reply or rejoinder? This is not an absolutely, it's not an imperative. This is to be decided between the board and the parties, unless there is an application proceedings. And I would say that not having a reply and a rejoinder has some advantages because it means some costs which are we make the economy of some costs and some time, but at the same time it must be decided in light of the preparedness of the case. Did we really prepare the case well enough in the memorial or counter memorial not to need a second round of written pleading? So these are the kind of strategic decisions which are taken at that stage. And then there are a lot of strategic decisions in the use or not of incidental proceedings. In particular, the preliminary objections. Preliminary objections is when a state challenges the jurisdiction of the court, and of course it is the right of a state to challenge the jurisdiction of the court. But the preliminary objections have the effect of suspending the proceedings on the merits while we have a judgment on these issues concerning the jurisdiction. The first reaction from a defendant which is surprised by the unilateral stance by the other party would be to challenge the jurisdiction of the court. But then we have to discuss, me as a lawyer, I'm discussing with the states I'm representing, what are the chances of winning. If there are no chances of winning, what are the advantages of introducing preliminary objections? Do we want to gain some time? In that case, it may be reasonable to introduce preliminary objections, so we must be really careful of what are the needs of the state when we are considering the strategical use of incidental proceedings, in particular of preliminary objection, but it will be the same for provisional measures, but I think Dr. Giacomo will discuss it later, so I will not bring this up. But there are elements of strategy in deciding if we are requesting or not provisional measures.